Good morning, everyone, and thank you for joining the session. I'm Bob Fahy. I'm an employment partner. I was going to say in the firm's London office, but of course, not many of us are fully in our offices yet, which is obviously part of what we're going to be talking about today. Today, Kathy and I are going to cover a broad overview of the employment implications of the COVID-19 coronavirus vaccine in an employment context. I'm going to start by looking at the guidance that is currently available for employers in relation to vaccinations in the workplace. I'm going to look at mandatory vaccinations in care homes. We've got a fairly wide spread of people joining us from various different sectors, which do include some people in the adult social care sector. So I will cover it. I will try and cover it in relatively light detail because I realise that many of you are not involved in the particular sector. I will also have a look at vaccination as a condition of attending the workplace and an employer's ability to instruct employees to get vaccinated. And those two, we think, two ever so slightly different scenarios, the one being the precondition to attend work and the other being an outright instruction to get vaccinated, the latter of which is going to be much more difficult to apply, and the former, I think we might have a bit more flexibility. And I'll just look relatively briefly at some of the practical objections that workers may have to a requirement to be vaccinated. And then Kathy will take over and look in a bit more detail at some of the potential discrimination issues, particularly indirect discriminations that may arise from a policy requiring people to be vaccinated before they can come to work premises. And then she will look into a couple of points about recruitment and how you can deal with vaccination issues on recruitment. And then she'll cover issues arising in relation to PCR testing and self-isolation in relation to vaccinated workers. So there's a fair amount of guidance for employers that's currently available. The two main documents that I'd flag up to you are PHE's Guide for Employers in relation to vaccination and ACAS's guide, Getting the Coronavirus COVID-19 Vaccine for Work. So PHE's guidance starts by noting that employers play a vital role in helping to promote vaccinations as part of their responsibility to help reduce workplace risk. And it urges employers to encourage employees to get vaccinated. And then the rest of the PHE document is largely concerned with facilitating ways that employers can promote vaccine uptake in amongst their workforce. And so that includes providing a link to an employer's communication toolkit, and that includes resources such as briefing sheets, Q&A documents, statistics and key messages. They include email sign-off wording that you can attach to your own email sign-offs, promoting vaccination and the like. And they also make a number of recommendations about options open to employers to encourage uptake of the vaccine. And they include things like appointing departmental champions to promote vaccine uptake, signposting employees to experts and community leaders, being open about support provided to facilitate workplace vaccination. And by way of example, they suggest, for instance, you may wish to consider giving paid time off to attend vaccination appointments. They also talk about considering amendments to any policies such as sick leave policies that may disincentivize employees from getting vaccinated. For instance, and I think this is picked up in the ACAS guide as well, one suggestion might be to pay full pay if employees have to take sick leave due to vaccination side effects. So that's worth looking at, and it's worth following the link to the employer's communication toolkit to see if there's anything out that can be of use to you. The ACAS guide, it's called Getting the Coronavirus COVID-19 Vaccine for Work. And again, largely its focus is on advising employers to encourage and support their staff without making vaccination a requirement per se. As with many ACAS guides, and I don't say this by way of criticism, because of course they have to apply general principles rather than give specific advice, but it's framed in broad terms. So, for instance, the ACAS guide notes that if someone does not want to be vaccinated, the employer should listen to their concerns. It points out that some people may have health reasons for not wanting to get the vaccine. For instance, they may be at risk of an allergic reaction, and recommends that employers are sensitive towards such personal situations and, of course, keep them confidential. And there's a recommendation to avoid discrimination, which I think, unsurprisingly, we're all going to be keen to follow. Other examples of the kind of broad term advice, ACAS suggests that it's best to support staff to get the vaccine without forcing them to. But that's not an outright prohibition, and it does note that if an employer feels it's important for staff to be vaccinated, it recommends that the employer should talk to staff or recognise trade union representatives to discuss what steps to take, and any decision after such a discussion should be put in writing in a workplace policy and should be in line with the organisation's existing policies. So it's nothing that you wouldn't expect, I think, but sort of a sensible framework for encouraging staff uptake and a bit of guidance about what to do if you actually do want to put some kind of policy in place. And they also make the point, which obviously we would support, that it's a good idea for the employer to get legal advice before bringing in any vaccine policy. And then the last point on this slide, just to mention that in a statement made on the 15th of April this year, the chair of the Equalities and Human Rights Commission, Baroness Faulkner, warned against vaccination certificates to help reopen society, saying that actually, in the HRC's view, there's a risk that this could create a potential two-tier society. And you may remember that phrase; it was fairly widely reported in mid-April this year. Within that statement, and this isn't necessarily strictly applied to workplace situations, but the HRC also commented that blanket mandatory vaccination policies applied inflexibly are likely to be unlawful due to the vaccination not being suitable for everyone, as well as the specific discrimination risks. And we'll come on to those in a bit more detail shortly. So if we could go to the next slide, please, Amy. In relation to mandatory vaccinations in care homes, as I say, I don't want to dwell on this too long because I realise that it only applies to a relatively limited number of delegates today. But the government's policy or rules requiring mandatory vaccination in workplaces comes into force on the 11th of April this year. And that means that because of the timing issues around being fully vaccinated, it means that the last date for workers to get their first vaccine dose, so they're fully vaccinated by the time the regulations come into force, is 16th of September 2021. So there's not a great deal of time left. These rules applies to workers deployed in CQC, that's Care Quality Commission, regulated care homes in England. And all workers to whom the rules apply must be fully vaccinated unless they're exempt. So workers in this context includes obviously your normal staff, but it also includes agency workers, volunteers, contractors, and self-employed people who carry out work in the home. Exempt workers in this context includes obviously anyone with a medical exemption, but it also includes those providing emergency assistance or urgent maintenance, and workers who don't enter the home. And also, exempt workers also includes under 18s. So just to give you a bit of an example around that, if you had a self-employed hairdresser who went into CQC regulated care home to provide her or his services, then that person would come within the rules. If you had a self-employed gardener who attended the home to care for the gardens but didn't go inside the home, then she or he would be exempt. And as well as this obligation applying to all of the employees who are not workers who are not exempt, there is an obligation on the employer through its registered person, that's the person who is registered for regulatory purposes with the CQC, to ensure that no person enters a care home unless they provide evidence that they have been fully vaccinated or that they are exempt. And the rules strongly recommend that each employer covered by the new rules puts in place a vaccination policy, setting out in full their application of these requirements. So that's probably everything to say about mandatory vaccination in care homes. Amy, if we can move to the next slide, please. So as I said in the introduction, it may be a relatively fine distinction, but we do think there might be a distinction to be drawn between a mandatory vaccination requirement per se and a policy that without a vaccination you are not going to be permitted to attend work premises. An actual instruction to employees that they must be vaccinated is likely to be at best unenforceable and probably unlawful. There's no statutory framework allowing employers to compel employees to have a vaccination, and the risks include both practical and legal ones. In practical terms, the most obvious difficulty would be the availability of the vaccine itself. Of course, the vaccine isn't widely available privately, so by and large, most of your workforces will be reliant on being given their appointments for a vaccination by the NHS. And until such time as they receive those appointments, they wouldn't be able to comply with such policy. Because of those practical concerns, it is therefore quite likely that an outright instruction that an employee has to be vaccinated, full stop, could amount to a repudiatory breach of contract, entitling them to claim constructive unfair dismissal, providing, of course, that they've got the necessary 2 years service. There are also a number of potential discrimination concerns, and Kathy will deal with these in more detail, but we're largely concerned with indirect discrimination risks where particular groups with a shared protected characteristic are less able to comply with an instruction to be vaccinated due to that characteristic, and the employer is not in a position to objectively justify the PCP, the provision, criterion, or practice that entails that policy. I've also seen commentary that actually jabbing someone against their will would amount to a criminal offence and would be an assault and battery. But of course, you're not going to be running around your workplace with vials of vaccine injecting your employees against their will. So an interesting legal point maybe, but I suspect not one that's likely to apply much in practice. So there are an outright instruction to be vaccinated, full stop, is not likely to be lawful. But there is, and similar considerations will apply to putting in place a no jab, no job policy, or a policy that an employee is not allowed to attend the workplace unless, as a precondition to that, they have been fully vaccinated. But there is likely to be a greater degree of flexibility to apply such policy in some circumstances. So if we move to the next slide, please. I'm just going to have a relatively quick look, and I see I'm already getting slightly over time, so I'll run through this relatively quickly before I hand it over to Kathy, who will deal with this in more detail. The potential obstacles and objections that employees might have to a requirement to be vaccinated. So in relation to immune system disorders, hopefully this is relatively obvious, but people who are immunocompromised are not being offered the vaccine at the moment, and they're considered it's not suitable for them. So they simply wouldn't be able to comply with such a requirement. And it is likely that such an immune system disorder would meet the definition of disability. It would amount to a physical impairment with a substantial long-term adverse effect on ability to carry out normal day-to-day activities. So it would be likely to be, and of course these things are always fact-specific, but in most cases it would likely to be a protected characteristic for discrimination purposes. In terms of pregnancy, or indeed women who are trying to conceive, it's worth noting, and I'm sure Kathy will cover this in a bit more detail, but the guidance has changed in relation to pregnant women. And based on studies of pregnant women in the United States who have been receiving the Pfizer BioNTech and Moderna jabs, the PHE is now happy that there's no material risk to pregnant women, and the vaccination is now being offered in the UK to pregnant women. But because until relatively recently, the jab was not available to pregnant women because of insufficient medical data about its potential side effects, you may well still have a degree of reluctance or concern that you might have to engage with. I'll mention long COVID, and I think I'll probably not go into much detail around ethical or religious concerns due to time, but if you've got specific questions, or if Kathy doesn't cover them, we can answer them. With long COVID, it's just worth mentioning that current PHE guidance to medical practitioners notes that individuals experiencing prolonged COVID symptoms may need to defer vaccination to avoid incorrect attribution of any change in the individual's underlying condition to the vaccine, which means that people with long COVID are unlikely to have the vaccine available to them, and therefore may well not be able to comply with such a policy. So I'll skip over ethical and religious concerns. In terms of alternatives to mandatory policies, if they might not be suitable for your particular sector or workforce, largely those are the options covered in the PHE and ACAS guidance. So engaging with your workforce about concerns, providing signposting and supporting good medical information about the benefits of the vaccine, providing departmental champions, referral points to experts and community support, and generally trying to support engagement and willingness to for the uptake. So I think those are all the points that I wanted to cover. And now I'll hand over to Kathy to deal in a bit more detail with the discrimination issues and then the other points that we were going to go through.
Thank you, Bob. So if you do decide, despite the guidance, to introduce a compulsory vaccination policy, or perhaps you're required to do so either because you provide workers to a care setting, or because other clients of yours are requiring you to do so. So we're having quite a lot of inquiries from hospitality, for example, where they're wanting their service providers to have assurance that their workers are double jabbed. Then one of the biggest risks is an indirect discrimination claim. So we're going to have a quick look at each of the protected characteristics that might be engaged. So the first one is disability, and as Bob has highlighted already, somebody with an autoimmune condition is quite likely to satisfy the definition of disability and therefore be protected against discrimination. It might also apply to people who have severe allergic reactions or to people with mental health issues that mean that they're not able to engage with the vaccination process. The second protected characteristic is age. Again, there's a timing issue here. Younger workers have only just had the opportunity to have the vaccination. But even leaving that aside, younger workers may be more cautious about taking up the vaccination due to their lower risk of severe reaction to the illness or hospitalisation or death, and their slightly higher risk that they have of blood clots. And there may also be fertility concerns for younger women, as Bob's highlighted. Religion and belief. Individuals may object to vaccination on religious grounds, either linked to the way in which the vaccination has been developed. Sorry, I've got a croak in my throat. And it is the case that there's no gelatin in the COVID-19 vaccination, but embryonic tissue has been used to develop the vaccine. So some religions might object to it on that basis, or on the basis that any medical intervention is in itself wrong. And there might also be a philosophical objection to the vaccination, either because of the way it's been developed, ethical veganism, or more generally, that vaccines are harmful to public health, the so-called anti-vaxxers. I think the legal consensus is that anti-vax beliefs are unlikely to satisfy the quite stringent test for a belief worthy of protection, but this hasn't yet gone to tribunal, so there's no certainty on that. And certainly ethical veganism has already gone to tribunal and has been found to be a protected belief. So individuals who object to taking the vaccine on that grounds may well be protected. Looking at sex, as Bob highlighted, there's now a slightly old survey which found that women aged 18 to 34 were in the group that showed the greatest resistance to vaccination, primarily due to concerns about fertility. And also if you're pregnant, because of that change in guidance, a lot of pregnant women are going, well, actually, if they said we shouldn't have it, now they're saying we should have it, we perhaps won't, we'll just protect ourselves in other ways. Pregnancy in itself is not something that is a protected characteristic for indirect discrimination purposes, but may give rise to a sex discrimination. The last protected characteristic we wanted to look at was the fact that vaccine take-up in some ethnic minority groups has been low. Some research published in April of this year showed that Black people were less likely than any other group to be vaccinated. So the take-up then was 64% of over 50s compared with 93% of white people of the same age. And other research has showed that Black ethnic groups had the highest vaccine hesitancy, followed by those of Pakistani or Bangladeshi origin. So reasons given are low confidence in the efficacy of the vaccine, distrust of the medical system, access barriers, and lack of communication from trusted providers. So a lot of work's been done with community leaders to increase take-up of vaccination, but there remains a risk of indirect discrimination. So as Bob said, the definition of indirect discrimination is requiring somebody to have applying a provision criterion or practice, a PCP, which may put individuals with a protected characteristic at a particular disadvantage. So the detriment in this case could be exclusion from the workplace or ultimately dismissal if you impose a compulsory vaccination. And there would be a risk of indirect discrimination claims on all of those grounds. So as we know, indirect discrimination can be objectively justified if an employer can show, firstly, that it was pursuing a legitimate aim, and secondly, that the measures that they're imposing, so in this case, the vaccination policy, actually contribute to the pursuit of that legitimate aim. And then thirdly, that the measures adopted are a proportionate way of achieving that aim. So there's not a better way of achieving it with less of a discriminatory impact. So certainly the aim of protecting the health and safety of staff and third parties is likely to be an uncontroversial legitimate aim for employers. So I think there's a tick in that box. It might, however, be harder to show that vaccination contributes to meeting that aim as on the grounds that it reduces transmission, as the scientific evidence in relation to vaccination, the impact vaccination has on transmission, is currently quite inconclusive. And likewise, proportionality might be hard to demonstrate. So can you say that a vaccination policy is the best way of protecting staff, as opposed to strict compliance with COVID secure guidelines, or introducing regular testing, or even home working or redeploying in some situations? All of these could be a more effective way of reducing the risk to staff and to third parties, and potentially be less discriminatory to each of those categories. So now moving on just to look at the impact on recruitment. Subject to the discrimination issues that we've just discussed, in principle, it might be easier to introduce a requirement that new employees have to be vaccinated rather than impose this on existing employees, which would require a contractual change in most instances. But there's still a number of issues. So firstly, you've got Section 60 of the Equality Act, which imposes a general prohibition on asking about the health of an applicant before you make a job offer. And you'll be aware as HR professionals that the purpose of this provision is to ensure that employees with a disability are objectively assessed in relation to their ability to do the job. So it is all right to make the offer conditional on satisfactory responses to health questions or checks, but obviously you still then can't discriminate against those applicants as a result of those health checks. So the first thing is it's currently not clear if asking about vaccination status in itself would be a prohibited question. So in relation to whether you should do it before you make the job offer, it would be safest at present to make it clear that vaccination would be a condition of employment, and that the employee will need to be vaccinated unless they are exempt, either on clinical grounds or for other reasons, but not ask for evidence of status until after the conditional job offer has been made. Secondly, and more generally, requiring full vaccination as a condition of employment can be problematic. We've already referred to the indirect discrimination, and that applies obviously to applicants as well as to employees. There are also significant, although not insurmountable, data protection issues. The ICO website has a vaccination section on it, which is a really useful reference point, and that applies not only to recruitment, but also if you want to have proof of vaccination for other reasons. For example, if you want to track staff vaccination levels generally to assess the risk of transmission, subject to the research on that, or as part of a wider health and safety assessment, or if you want to check if individuals are no longer required to self-isolate following a track and trace notification following the changes on the 16th of August. In all cases, the vaccination status is health information, which falls into special category personal data and attracts the higher level of protection. The details of that protection are outside the scope of this session. But please raise a question if you have something specific to ask about that. Bob and I will do our best to answer it, but we're obviously employment lawyers, not data protection specialists. And finally, just highlight there are a few practical issues. In an increasingly competitive job market, the requirement may put candidates off or cause delay to the recruitment process if you're trying to track down and verify a vaccination status. If it's only a requirement for new staff, it may cause employee relation issues. You'll effectively have a two-tier workforce, which is not something we would normally recommend. And if you do choose to impose it on all staff, despite the guidance and the risks, you are likely to be changing contracts, and that is in itself not a straightforward process. And ultimately, if you decide to impose a compulsory vaccination policy, you would have to either redeploy or dismiss an employee who does not agree to be vaccinated. Then you may face a claim for unfair dismissal as well as for discrimination. And we're sort of expecting that there might be a few questions on that in the Q&A session. So the last topic we're going to look at briefly is the impact of vaccination on the requirement to self-isolate and the impact on sick pay. This might be another reason why you want to impose a vaccination policy. It remains the case that if an employee develops symptoms, they should self-isolate immediately and book a PCR test as soon as possible. And if that test is positive, they have a legal requirement to continue to self-isolate regardless of their vaccination status. And that's the 10 days in England from the start of the symptoms or from the date of the PCR test if they're asymptomatic. And if that test is positive, they remain entitled to SSP. However, if you're contacted by track and trace, test and trace, a fully vaccinated individual now no longer needs to self-isolate, so that provided they've had a jab, at least the second jab at least 14 days ago, and that came in on the 16th of August. And the same applies if they're taking part, if you as an employer are taking part in a daily contact testing scheme, a DCT scheme, which some of you may well be testing. I know some of the delegates who booked on, I'm not sure whether they've attended, are participating in that. So the advantage of having a vaccination policy might be to reduce absence from work as well as the transmission point. So what do you do if someone chooses either not to disclose they are vaccinated or to self-isolate anyway, even though they're vaccinated? Well, there's no clear guidance on whether they're entitled to SSP at present. You'll recall the SSP regs were amended to provide that SSP is payable as of right when self-isolating in accordance with guidance. But those guidelines have not yet been updated, and nor have the regs to reflect the 16th of August changes. So those regs can therefore be read to confer the right to SSP in these circumstances, however illogical that now seems if somebody chooses to self-isolate even though they are double jabbed and don't need to. And our clients are actually taking different approaches. Some are saying, actually, we'll just pay SSP until the regs change, and others are saying, do you know what, we'll wait and see, if there's further clarification in the guidance. Okay, that's all we had to say. I know there's a few questions in the chat already. So Bob and I are now going to answer your questions. And I think Amy's going to come back on and host.
Brilliant. Yes, we've had quite a few questions in. So the first one we've got is, are we able to ask employees for evidence that they have had both the vaccinations to enable to be released from the 10 days isolation if they have been in contact with someone with COVID-19? Wales does not at present have the NHS COVID-19 passport.
Thank you for that one, Amy. Well, that does relate back to the data protection issues that I alluded to very briefly, which is that you will need to, so that is sensitive personal data. Bob, interrupt me when I go badly wrong, but it's sensitive personal data. So it needs to be dealt with in accordance with your data privacy policy. You might not have a contractual right to ask for it unless you've put something in your contracts. So your policy could be that you require people to do it, but you would probably need to consult with employees about that as part of your wider health and safety risk assessment, and with employee representatives, health and safety representatives, before you impose that requirement. I mean, if people volunteered to show it to you, then you would just need to make sure that you dealt with the data appropriately in accordance with processing that. If you record it, I think is the case, not if you just look at it to say. So I think a lot of employers are just saying, if you tell us, we're going to take it on trust, rather than having to do that constant verification. But if you're in a health setting or you're dealing with vulnerable people, that obviously that might not be acceptable. Bob, anything?
Just to pick up actually on one of the points you made, Kathy, the ICO guidance actually states that where an employer is only conducting a visual check of COVID passes and does not retain any personal data from the check, this would not constitute processing in the ICO's view and falls outside the scope of the Data Protection Act requirements, in contrast to where checks are carried out digitally, for example, by scanning the QR code on a pass verifier app. That would constitute processing personal data, even if the employer doesn't keep a record of it, and Data Protection Act would apply. And then there's also just some general commentary in the guidance about the sector in which an employer operates, the nature of the work carried out by its workers, and the particular health and safety risks being relevant in deciding whether employers have legitimate interests. And I think if you are waiving a self-isolation requirement on the strength of an employee's statement that they have been double vaccinated, that health and safety aspect may well weigh into the legitimate interest position. So it may support you checking the data, but of course, what the employee specifically does in your workplace and who they come into contact with is also going to be relevant. So it is going to be a case-by-case assessment.
And I noticed that a question came from somebody in Wales where they haven't got the NHS pass.
Yes,
so therefore, you might be able to just look at it if you're in England, but you probably will need something in writing, and that might be processing. And because it's sensitive, you therefore then need the legitimate, you need both the legitimate reason for processing and the condition for processing. So it gets a bit complicated. Although, the ICO is clear, I think, in the guidance that it will be possible to, if all of your risk assessments and your reasons are legitimate, then you will be able to ask for the information you need.
Brilliant. Okay, we've got another question here. If an employee has a medical exemption and therefore is not double vaccinated for a role that requires it, should we treat this person differently, perhaps on the grounds of disability, to those who refuse a vaccination?
Shall I pick that one up first because it's a discrimination? The answer, I think, is yes, because you'll have an obligation if they have a disability to make reasonable adjustments. So that is an extra layer of protection that particular individual has, in addition to all of the other layers of protection, is the short answer.
Okay, what is the position on care homes in Scotland if the home insists on mandatory vaccinations?
Well, shall I pick that up as I covered the care homes points? So the mandatory vaccination laws that are being implemented only apply in England. So a care home in Scotland that wishes to insist on mandatory vaccination as a condition of its workers attending the workplace will have to engage with all of the issues that we have been describing around potential employee reluctance. And where an employee is unable to comply with the policy should have sufficient flexibility to prevent to allow that. In practical terms, that will leave you with some real difficulties. So if you have immunocompromised employees working in your care home, for instance, then having a policy that they are not entitled to work unless they are double jabbed, and it's applying that to everyone except them, it's kind of have obvious difficulties, but attempting to apply it to them with the potential result that either they resign as a result of the instruction, or you are required to terminate their employment because they're unable to require with the policy, does have potential discrimination risks. There's no getting around that difficulty. So it may be that you are nevertheless able to objectively justify the policy on the basis of the levels of risk to your residents, and that that objective justification also constitutes a fair basis for you to give a lawful instruction not to attend without being double vaccinated. So when I say there are risks, I'm definitely not saying that it's inevitable that successful claims arise, but it is going to be a potentially difficult situation for you to engage with.
And of course, in England, the regulations specifically exempt discrimination claims if somebody is dismissed because they can't comply with the double vaccination. So the next question also links to that as well. If someone refuses the mandatory vaccination in care homes, do we proceed with alternative employment and then dismiss? And I think the answer to that is yes. You have a reason for looking at dismissal, but you still need to go down a fair process. And as part of that fair process, there'll be consultation about the reasons and looking at alternatives to dismissal. And that might well include looking at alternative positions, redeployment, working from home. So, all of the normal raft of protection, will apply. I'll just carry on with the next one, which is, have any cases been linked to termination following long COVID? Long COVID, I'm not aware of any that have come through yet, Bob, although we are advising on a number of cases. I mean, almost by definition, the dismissals are likely to be a bit of the way down the line.
Yes.
There've obviously been a number of COVID dismissal cases, but not long COVID. But I suppose, in the end, general capability principles will apply, which is if that somebody is affected for such a long time that they can't come back to work, you'll look at the impact on the organisation and colleagues, and ultimately that would be a capability dismissal with some element of disability discrimination if it satisfies that test.
Brilliant. On to the next question. How strong is an argument that the vaccine only gives protection to the individual and doesn't reduce the risk of either contracting the virus or passing it on?
I think that's a question for a doctor rather than a lawyer.
I don't think it's legally persuasive yet. I think I said in mine that the evidence on transmission isn't conclusive, and that's one of the reasons that makes the legitimate, the objective justification to a discrimination claim slightly problematic at the moment. I think that there was one that said it reduced it by 50%, one study, and then another study seemed to throw doubt on that. I'm not reviewing all of the medical research on a daily basis, but I think that's one of the things you'd need to take into account in doing your health and safety risk assessment and deciding whether you were going to impose a compulsory vaccination requirement.
Amy, can I just pick up? I don't know if you skipped over question about deliberately or not, but there is a question from an anonymous attendee saying that their employer provides services to care homes, so needs to develop a policy to support covering double vaccination, and asks what are the key themes we should cover in the policy, and do we know if there are any templates available. So there is guidance. There's from the DHSE. There's operational guidance on the vaccination of people working or deployed in care homes. It was published 4 days ago, and it's there to help support the implementation of the Health and Social Care Amendment regulations that implement the mandatory vaccination policy. In that guidance, there's a link to a vaccine communications toolkit for adult social care, and that contains a number of resources, including Q&As on the vaccine, guidance, resources addressing common concerns about the vaccine. It doesn't contain a template policy per se. We have been helping some of our clients in the care home sector with their own vaccination policies, so if that's something you do need assistance with, please do get in touch. But for free resources, generally, the operational guidance and its link through to the toolkit are well worth looking at.
Brilliant. Okay, on to the next question. How should we treat someone who is a close contact and advised to self-isolate but has chosen not to get double jabbed?
Fairly.
Is that all for you?
Fairly. Well, if you don't have a vaccination policy, then you treat them in accordance with the current guidance, which is they should be self-isolating. And then currently, if they're self-isolating in accordance with guidelines, they would be entitled to SSP. And the fact that they've chosen not to get double jabbed shouldn't result in any penalty to them. Obviously, if you are imposing a compulsory vaccination policy, then the answer to that question would be different and would be covered by your policy. So you would explain what the consequences would be if you've chosen not to be. We have got some clients who are saying, obviously, we're not requiring you to be double jabbed, but actually, if you've elected not to, and there will be a start date for this policy, we are no longer willing to pay company sick pay to people who've had to self-isolate, although we have done previously to encourage self-isolation, because actually you're sort of making a choice that means that you're more likely to have to self-isolate. Again, there's some discrimination risks with that, which you'd want to consider and address, but that seems to me quite a sensible approach in general terms.
Brilliant. Okay, next question. How would you deal with a member of staff who refuses to do LFTs or have the vaccination and is now saying they don't want to wear masks, even though the job means they can't keep a distance from others? Staff are feeling very uncomfortable.
Well, I think that moves somewhat more into the territory of your employer's health and safety duties to ensure a COVID-safe workspace. And obviously, there are a range of potential actions that you can take depending on the work that your employees are doing. And if you have a situation where social distancing is impossible because of the nature of the work, then the other risk mitigation factors become more important. And they will certainly include mask wearing in cases of close proximity. So I think there we're more in the territory specifically in relation to not wearing a mask whilst in close contact with others, of first trying to deal with it through informal line management action, of course, which is always the best first step, and explaining that it's a requirement. And then if the employee continues to refuse to comply, I think you can take it down the road of a reasonable line management instruction and start to consider formal disciplinary action. Kathy, anything to add to that?
No, I think that's exactly right. Yeah. And we are beginning to, people are being awkward, and we are beginning to have to advise on these situations quite a lot. So you're not alone, whoever that was.
Brilliant. Okay, next question. Can you clarify, please, can we determine not to pay someone if they self-isolate for 10 days and they have determined themselves not to be double vaccinated, not for any particular reason or from any protected characteristics?
Well, this was the point I actually covered. The question might have gone in before we covered this, but the SSP regs haven't been updated since the guidance changed on the 16th of August, so the position is a little unclear at the moment. It seems illogical, doesn't it, that they should still be protected if they've elected not to take the protection. But the SSP regs, when strictly read, could imply that they're still entitled to. So we're sort of expecting them to be changed. And as I said, employers are opting to take different approaches to that, depending on their primary aim, which is whether it's to get people back to work as much as possible, or whether they're much more, conscious that they haven't got the right to ask people even to share their vaccination status, and therefore they're not really going to grasp that nettle of saying you're vaccinated, so you're self-isolating when you don't need to. Yeah.
Okay, brilliant. I think we've got a couple more left. What if an employee who has been double vaccinated decides to self-isolate during working hours, but does not isolate outside these hours, for example, going shopping or days out the weekend?
Brilliant. Well, they're not self-isolating at all in those circumstances, are they? So what you have is an employee who has failed to attend work in circumstances where they're not self-isolating. And if they have told you that they are self-isolating, then they appear to have, and you will need to look into whether disciplinary action is appropriate, and if so, go through a disciplinary process on the basis that they may have deliberately misled their employer as to the reasons for their failure to attend work. It could be quite a serious disciplinary matter.
Yeah, certainly dishonesty, and also if they should be self-isolating, they're also breaching the regulations as well, although that's not something directly for the employment, for you as an employer.
Okay, great. I think we've got 2 questions left. What is the position if an employee requests 100% home working because they have chosen not to accept the vaccination, not because they have a disability or any other conditions?
Do you want me to start, Bob?
Yes, please.
Well, that would be a flexible working request, almost certainly, and I suppose to some extent, if there's no discrimination issues, then really you're looking at that under the formal flexible working request, your policy, and in accordance with the statutory requirements. So anyone can make a request for flexible working, and one of the things they can request to do is to work from home, and you would want to address that in line with the statutory guidance and in line with your own policy on home working and or hybrid working if you've introduced one. So you would need to look at the impact on their role, whether they can do the role from home, the impact on colleagues, and the impact on client service and all of those things that are listed. I think what we're finding with these formal flexible working requests is, of course, it is slightly harder to say it can't be done if over the last 18 months people have in fact been working 100% from home and actually have been doing their jobs. So the grounds on which you could say no might be somewhat more limited, evidentially. Bob, I don't know if you've got any views.
No, well, I'd agree with that, although I did have clients who were during the mid-period of the pandemic lockdown in the summer of last year, when it looked like we might be opening up a bit, talking about the fact that in their particular sector, this was a life sciences pharmaceutical company, their employees were working from home, not always entirely successfully. So they were able to work from home, but there was downturn in appointments with NHS contacts and reduction in turnover of the company overall in that financial year. So the question of being able to work from home might be a fairly malleable concept when you start digging into how well or what detriments the business suffers as the result of the home working. So you can get down into some quite fine levels of detail once you start to really look at the situation.
And we're also finding, the first place to go is definitely to try and coax people back into the office or the workplace. And very often people who are very, very resistant if they can be encouraged into the workplace, perhaps out of hours when it's quiet, and just remember what it's like, see the COVID secure stuff that's been put in place in the workplace. Actually, for a lot of people, not everyone, but for a lot of people, once they start the process, it's easier to get them back in than you expect. But generally speaking, leaving that aside, that there is no reason for them to be home working other than they want to be. The fact that you've got a COVID secure workplace, and if they're not accepted the vaccination, that makes no difference to the legal position.
Brilliant. I think we have one last question. If an employee has had their first vaccination but not their second and are required to isolate, what is the employer required to do in this case?
I've lost the question now. I was scrolling down because there were actually a few more questions.
That's essentially the requirement to isolate still applies to them, I think. Kathy, isn't that right? The exemption from self-isolation only applies.
Yeah, that's right. Yeah, once you've had, and 14 days after your second vaccination. So that's absolutely right. It still applies until 14 days after the second vaccination. There were a couple more, Amy. I don't know if you've.
Yeah, I can't seem to see any more. These are the only ones that are up on my Q&A. So if you see any more,
So can employees hold employee vaccination status on employee files to enable us to deal with absence regarding isolation? Not copies of their certificates, but just a note to say fully vaccinated or not. Would this fall under legitimate interest? I think that the short answer is potentially yes. But you would.
I was going to say it depends, but that's better.
Yeah, I think if you can show the legitimate interest and the condition for processing, which is for the purposes of employment or the health condition, then you should be okay. It's a very complicated area, and as I think I said, the ICO guidance is clear that if you have a good reason for wanting it, and I do think absence regarding isolation is potentially a good one, then actually that's a legitimate interest, and therefore you should be able to align all the data protection behind that. But as Bob said earlier, if you're keeping a record, then that is processing. So you fall into the whole GDPR. You need to amend your privacy notice policies, have retention information. And I think they say keep it under review, because this is an area that's developing. So it's not like you're going to have a policy now which will remain in place necessarily for the next year. You would need to keep that under review and amend it so that you're not retaining information that you no longer need. And I think there was one more above, wasn't there? Which is, we should just have time for. We have a double vaccinated teacher who is shortly reaching their third trimester in pregnancy. What do we need to consider for her in teaching within school? She cannot work from home as a teacher. Does she just need to follow government guidance on social distancing? I think the attendee here is referring to the guidance that came out from the Midwifery Council and the GMC, I think, about the increased risks to individuals in their third trimester. And certainly when cases were high, a lot of schools were sending teachers home to work from home if they couldn't be safeguarded in school with social distancing. So I think the short answer is yes, the teacher does need to follow government guidance on social distancing, but you will have to do a pregnancy risk assessment for them anyway, as well as the general COVID risk assessment. And depending on the particular situation of her teaching, how she teaches, where she teaches, can you social distance, and probably the number of cases in the school at any given time, given the risk to pregnant employees in their third trimester, you may need to take different action with that person, and potentially, at the worst, move to medical suspension if there are really no alternative duties, or you can't safeguard her in the school. But that will need to be a specific risk assessment for her as a pregnant woman in the particular situation she's in. Bob, any comments on that?
No, that very thorough. Nothing to add to that.
We've just had one more come in at the bottom if you want to quickly have time to answer this one. It says, is it possible to send an example of a vaccination policy, please?
I will pick that up with the individual concerned afterwards, if that's okay. Yes, we have vaccination policies, but obviously they're different for every organisation. So it's not a standard, I suppose, but examples we do have.